Contract Law, Insurance USA. To meet the requirement of legal purpose, the insurance contract must be supported by an insurable interest. See further discussion below. It may not be issued in such a way as to encourage illegal ventures, as with marine insurance placed on a ship used to carry contraband. In general, an insurance contract must meet four conditions in order to be legally valid. It must be for a legal purpose. The parties must have a legal capacity to contract. There must be evidence of a meeting of minds between the insurer and the insured, and there must be a payment or consideration. The requirement of capacity to contract usually means that the individual obtaining insurance must be of a minimum age and must be legally competent. The contract will not hold if the offer is generally made on a written application for insurance. In the field of property and liability insurance, the agent generally has the right to accept the insurer's offer for coverage and bind the contract immediately. The payment or consideration is generally made up of two parts, the premiums and the promise to adhere to all conditions stated in the contract. These may include, for example, a warranty that the insured will take certain loss prevention measures in the care and preservation of the covered property. Warranties. In applying for insurance, the applicant makes certain representations or warranties. If the applicant makes a false representation, the insurer has the option of voiding the contract. Concealment of vital information may be considered misrepresentation. In general, the misrepresentation or concealment must concern a material fact defined as a fact that would, if it were known, cause the insurer to change the terms of the contract, or b. If the agent of the insurer asks the applicant a question, the answer to which is a matter of opinion. And if the answer turns out to be wrong, the insurer must demonstrate bad faith or fraudulent intent in order to void the contract. If, for example, in answer to an agent's question, the applicant reports no history of a serious illness in the mistaken belief that a past illness was minor, the court may find the statement to be an honest opinion and not a misrepresented fact. A basic principle of property liability insurance contracts is the principle of subrogation, under which the insurer may be entitled to recovery from liable third parties. In fire insurance, for example, if a neighbor carelessly sets fire to the insured's house and the insurance company indemnifies the insured for the loss. The company may then bring a legal action in the name of the insured to recover the loss from the negligent neighbor. The principle of subrogation is complemented by another basic principle of insurance contract law, the principle of indemnity. Under the principle of indemnity, a person may recover no more than the actual cash loss. One may not, for example, recover in full from two separate policies if the total amount exceeds the true value of the property insured. Insurable interest closely associated with the above legal principles is that of insurable interest. This requires that the insured be exposed to a personal loss if the peril insured against should occur. Otherwise, it would be possible for a person to take out a fire insurance policy on the property of others and collect if the property burned. Any financial interest in property or reasonable expectation of having a financial interest is sufficient to establish insurable interest. A secured creditor such as a mortgage has an insurable interest in the property on which money has been lent. In the field of personal insurance, one is held to have an unlimited interest in one's own life. A corporation may take life insurance on the life of a key executive. A wife may insure the life of her husband. And a father may insure the life of a minor child because there is a sufficient pecuniary relationship between them to establish an insurable interest. A wife may insure the life of her husband. And a father may insure the life of a minor child because there is a sufficient pecuniary relationship between them to establish an insurable interest. In life insurance, the insurable interest must exist at the time of the contract. Continued insurable interest, however, need not be demonstrated. A divorced woman may continue life insurance on the life of her former husband and legitimately collect the proceeds upon his death even though she is no longer his wife. In the field of property insurance, on the other hand, the insurable interest must be demonstrated at the time of the loss. If an individual insures the home but later sells it, no recovery can be made if the house burns after the sale, because the insured has suffered no loss at the time of the fire. Liability law: in most countries, an individual may be held legally liable to another for acts or omissions and be required to pay damages. Legal liability exists when an individual commits a legal injury that wrongly encroaches the another person's rights. Such injuries include slander, assault, and negligent acts. A negligent act involves failure to behave in a manner expected when the results of this failure cause a financial loss to others. An act may be classed as negligent even if it is unintentional. Negligence may be imputed from one person to another. For example, a master is liable not only for his own acts but also for the negligent acts of servants or others legally representing him. It is not uncommon for a municipality to require that business using city property assume what would otherwise have been the city's negligence for the use of its property. Statutes may impute liability on individuals when no liability would exist otherwise, thus the parent may be legally liable for the acts of a minor child who is driving the family automobile. There are assumed risks, contributory negligence, and the fellow servant doctrine. In common law, countries such as the United States and the United Kingdom, three defenses may be used in a negligence action. There are assumed risk, contributory negligence, and the fellow servant doctrine. Under that assumed risk rule, the defendant may argue that the plaintiff has assumed the risk of loss in entering into a given venture and understands the risks. Employers formally use the assumed risk doctrine in suits by injured employees, arguing that the employee understood and assumed the risks of employment in accepting the job. Thanks for watching.